Thank you, Darren. I'll now discuss recent developments in the royalty and intangible space, which is a key area of focus for the ATO. In a recent decision, PepsiCo versus the commissioner, a single judge handed down the decision in favor of the commissioner. You see that PepsiCo and SVC are the respective owners to the portfolio of trademarks and designs to the Pepsi and Gatorade brands. They entered into exclusive bottling arrangements with EBAs with a third party, SAPL, to manufacture, bottle, and package beverages in Pepsi brands. Whilst the EBAs did not expressly provide for a payment of royalty for the right to use the IP, SAPL is granted an exclusive royalty right-free license to manufacture and distribute using those trademarks without any infringement of rights under the agreement. PepsiCo will still provide the marketing directives, but give the local markets enough flexibility in terms of the development of the marketing campaign to make sure it's locally relevant. Concentrate required by SAPL was produced by a Singapore entity, CMPL. From January 2018, CMPL entered into a concentrate distribution agreement with PBS, another Australian entity, which was nominated as the seller under the EBAs. Over the course of the 2018 and 19 income years, SAPL made 240 million in payments under the EBAs to PBS for supply of the concentrate only. In turn, this amount was returned by PBS less a margin of 0.05% to CMPL. Darren, can you go to the next slide? So the single judge agreed with the commissioner's agreement that the royalties were embedded within payments made by SAPL for the concentrate, as SAPL wouldn't have been able to manufacture, package, or sell the beverages without the use of the relevant Pepsi trademarks, formulas, specifications, etc. It was considered inconceivable that PepsiCo was willing to license its brand to a third party for no compensation, particularly given the global strength of its brand. The nomination of PBS did not change the fact that PepsiCo and SVC were sellers in the EBAs and therefore beneficially entitled to the payments made under Article 12 of the US and Australian Treaty. Though not necessary, the court also considered and concluded that the diverted profit tax, DPT, was applied as an alternative, as one of the principal purposes was to obtain both local and foreign tax benefits, that is not paying the Australian withholding tax and reducing US income. To recap, DPT applies to tax benefits obtained for income years commencing on or after 1 July 2017, regardless of when the scheme was entered into or carried out. It only applies to significant global entities, which Darren touched upon earlier. A 40% tax rate would apply instead of the usual 30%. And the principal purpose test under DPT is intended to have a lower threshold than the sole or dominant purpose test under Part 4A. In this instance, the taxpayers have now lodged an appeal to the full federal court. And in case you were wondering, there's also a similar case in the pipeline for Coca-Cola, so watch this space.